All right, here are the answers to the tests for Volume 2. This is going to be Section D of our essential skills. So here we go. Yay! All right, Combined Test Prep A. Which of the following statements is accurate? The answers A and B. Affirmative defenses, if there are any, are usually provided with the answer. Turning down my Gregorian chants, or they're a little loud. Okay. So which of the following statements is accurate? Affirmative defenses, if there are any, are usually provided with the answer. And a counterclaim is basically the defendant's complaint against the plaintiff. It's B, so it's A and B. A summons is not a pleading. It is considered an instrument, although it usually is kept in the pleading section of a client file. Interrogatories are a form of discovery. So which of the following statements is accurate? Affirmative defenses, if there are any, are usually provided with the answer. A counterclaim is basically a defendant's complaint against the plaintiff. When pinpointing a citation, if there are parallel sites, pinpoint all parallel sites. The general rule is that if one publication within a citation is pinpointed, all other sites must be pinpointed as well. Authority from a higher court within the same jurisdiction is usually referred to as mandatory. A lower court must follow relevant authority from a higher court. If your attorney is arguing a case in your state's trial court and you find a valid, relevant case that is from an appellate court in your state, that case would be primary, mandatory. Any authority from a higher court, a court higher than the court in which the matter is being argued, within the appellate jurisdiction, and that is relevant, would be considered primary, mandatory authority. When citing a case from a reporter, whether online or in a law library, in the case title at the top of the reporter page in all caps, the paralegal should change the all cap format to standard upper and lower case, first letter only in caps. Which of the following is a form book? It's going to be American Jurors Pleading and Practice Forms, Proof of Facts, and Benders. Those are following. Which of the following are form books? American Jurors Pleading and Practice Forms, Proof of Facts, and Benders. Reporters are not form books. They contain case law, not forms. There are dozens of examples of form books, including the ones listed above. Which of the following statements is accurate? A reply is a pleading. Depositions are part of discovery. Failure to respond to discovery may result in sanctions. Those are 3 accurate statements. A complaint is accompanied by a summons. Which of the following statements is true? When researching form books in the law library, start your research in the index. Well, there you go. Westlaw and Lexis both have strong collections of forms online. Form books are generally considered secondary authority. Which of the following statements is accurate? A paralegal should save almost all documents he or she creates in a form book or a form bank. A paralegal should ask the attorney for previously created examples of documents. A paralegal should not be afraid to ask other paralegals for forms or templates. Those are the answers. Don't start from scratch. Don't recreate the wheel. Always look for a form or template. When citing a case from a reporter, whether online or in the library, if the reporter places the unofficial citation prior to the official citation in its recommended citation at the top of the page, the paralegal should change the citation so the official is first. In proper Bluepick citation form, the official citation, if there is one, is always listed first. Here's combined test D. Multiple response 1. The exchange of information during the pre-trial stage of litigation is referred to as discovery. Sorry, making the page bigger so I can read it. Okay. Which of the following is a pleading? Answer, complaint, and reply. The generally recognized pleadings are complaint, answer, counterclaim, cross-claim, and reply. A successful complaint must contain at least one of these: a valid cause of action, a valid claim for relief. A cause of action and a claim for relief are the same thing. A valid complaint must contain at least one of valid claim or cause. A complaint must contain a caption, a summary, a caption, an establishment of jurisdiction, a prayer for relief. A prayer for relief is also known as the whereas for clause, or the wherefore clause, or addendum clause. Which of the following are always filed with the court? Motions. Discovery documents are not typically filed with the court. There are a few jurisdictions that require some discovery responses to be filed, such as requests for admission response, but that is not the general rule. So, which of the following are always filed with the court? The answer is C. Motions are filed with the court, always. It says always. The element of complaint that asks for damages is the wherefore clause, prayer for relief, addendum clause. Wherefore clause, prayer for relief, and addendum clause are all the same thing. They specify the relief being sought by the court. Of the court. A document filed with the court establishing a position on litigation is a pleading. A pleading informs the court of a specific legal deposition a party is taking in litigation. It also tells the court what the party wants the court to do. The plaintiff's complaint tells the court that the defendant harmed the plaintiff. The defendant's answer says, "No, I didn't. Please dismiss this case." The defendant counterclaim states, "No, not only am I not liable, the plaintiff harmed me and now owes me damages. I've been wounded. I've been afflicted." The defendant's cross-claim states it was at least partly this other person's fault. The plaintiff reply states, "The counterclaim is not true. I am not liable for damages to the defendant." Which of the following is a pleading? Answer, cross-claim, counterclaim. The generally recognized pleadings are complaint, answer, sometimes including affirmative defense, counterclaim, cross-claim, and reply. Which of the following is a pleading? Reply, third-party complaint. The generally recognized pleadings are complaint, answer, sometimes including affirmative defenses, counterclaim, cross-claim, third-party complaint, and reply. Which of the following involves a legal claim against another party? Complaint, counterclaim, cross-claim. A complaint is a claim by a plaintiff against the defendant. A counterclaim is a claim by the defendant against the plaintiff. A cross-claim is a claim by the one defendant against another defendant. All right, the next test is advanced authority. What court could possibly be mandatory on the federal trial court in your jurisdiction? The U.S. Circuit Court in your jurisdiction? The U.S. Supreme Court. The U.S. District Court is the federal trial court. Since it is not higher than itself, it could not be mandatory authority. So what courts could possibly be mandatory on the federal trial court in your jurisdiction? And the answer is the U.S. Circuit Court in your jurisdiction and the Supreme Court. The U.S. District Court is the federal trial court. Since it is not higher than itself, it could not be mandatory authority. Sorry, I had to make it bigger again, because I'm having trouble reading it. If your attorney is arguing a case in the highest court in your jurisdiction, usually called the Supreme Court in your state, and you find a relevant case in the U.S. Supreme Court, what kind of authority would that be? Primary, mandatory. The Supreme Court is mandatory on all other courts. Is your authority in arguing a case in the federal court in your jurisdiction? If your attorney is arguing a case in the federal circuit court in your jurisdiction and you find a relevant case from another federal circuit court, what kind of authority would that be? That would be primary or primary persuasive. Since the case found is from the same level of authority, and since it is from a different jurisdiction, it would be primary persuasive authority. Interesting. If your attorney is arguing a case in the federal circuit court in your jurisdiction, and you find a relevant case from the federal district court in your jurisdiction, what kind of authority would that be? Primary persuasive. Since the case found is from a lower authority, it would be primary persuasive authority. Mandatory authority must be from a higher court within the appropriate jurisdiction. In order to be considered mandatory, an authority must be from a higher court within the jurisdiction of the court the attorney is currently in. All right. If your attorney is arguing a case in the trial court in your jurisdiction and you find a relevant case in the federal circuit court in your jurisdiction, what kind of authority would that be? And the answer is primary persuasive. Since the case is found from a different jurisdiction, state versus federal, it would be primary persuasive authority. What courts could possibly be mandatory in your state's court of appeals? Your state's highest court, the U.S. Supreme Court. The answer is that question is the answer to what courts could possibly be mandatory on your state's court of appeals? Your state's highest court, the U.S. Supreme Court. Your state's highest court, the U.S. Supreme Court, are both higher and within the appropriate jurisdiction, and thus could be mandatory. By the way, the reason we don't just refer to your state's highest court as your state's Supreme Court is that a couple of states have different titles for the highest court. Most notably, New York calls its highest court the New York Court of Appeals. New York's trial court is called the New York Supreme Court, and New York's appellate court is called the New York Court of Appeals Appellate Division. If your attorney is arguing a case in the highest state of your jurisdiction, usually titled your state Supreme Court, and you find a relevant case from the Court of Appeals in your state, assuming your state has one, what kind of authority would that be? Primary persuasive. Since the found authority is lower than the court where the case is being heard, it would be considered primary persuasive. If your attorney is arguing a case in the state trial in your court, if your attorney is arguing a case in the state trial court in your jurisdiction and you find a relevant case from another state's highest court, what kind of authority would that be? Primary persuasive. Since the case since the case is from a different jurisdiction, a different state, it would be primary persuasive authority. What courts could possibly be mandatory in your state's trial court? Your state's Court of Appeals, assuming it has one, your state's highest court, the U.S. Supreme Court. All the above courts are higher authority within the appropriate jurisdiction and could be mandatory. The reason answer A above is phrased as the qualifying assuming it has one, referring to your state's Court of Appeals, is that a few states don't have intermediate Court of Appeals. Those states only have trial courts and Supreme Courts. What courts could possibly be mandatory on your state's highest court? The U.S. Supreme Court. In order to be considered mandatory, the authority must be from a higher court and within the appropriate jurisdiction. The only higher court than your state's highest court is the U.S. Supreme Court, which has jurisdiction over all courts beneath it. Persuasive authority can be from a lower court, from the same level, from any jurisdiction within the U.S. Persuasive authority is still good authority, even though it is not mandatory. Authority which the court can follow is called persuasive. Even though a court is not qualified to follow mandatory authority, it may still have significant weight. There we go. If your attorney, the operative word is that they can follow, not must. If your attorney is arguing a case in the federal circuit court of your decision and you find a relevant case from the highest court in your state, usually titled your state Supreme Court, what kind of authority would that be? B. Primary persuasive. Since the jurisdictions differ of federal versus state, it is primary persuasive authority. Authority which the court must follow is called mandatory. If an authority is mandatory, the court, in theory at least, has no choice but to follow that authority. Finding mandatory authority is actually not that common. If it were, there would not be so much litigation. Your goal is to always find mandatory authority. Your result is usually persuasive authority. What courts could possibly be mandatory on the Federal Circuit Court in your jurisdiction? The answer is the Supreme Court, U.S. Supreme Court. Only the U.S. Supreme Court is higher than the U.S. Circuit of Court of Appeals. If your attorney is arguing a case in the Federal District Court in your jurisdiction and you find a relevant case from a Federal Circuit Court in your jurisdiction, what kind of authority would that be? Primary, mandatory. Since the case is found from a higher authority within the appropriate jurisdiction, it would be a primary mandatory authority. On what courts could the U.S. District Court in your jurisdiction be mandatory? D, the state courts in your jurisdiction. There's no court lower than the U.S. District Court within the federal court system, and thus it could not be mandatory on any court. Interesting. If your attorney, you can read that again, there's no court lower than the U.S. District Court within the federal court system, and it could not be mandatory on any court. If your attorney is arguing that a case in your state's trial court, if your attorney is arguing a case in your state's trial court, and you find a relevant case from your state's highest court, usually called the Supreme Court, what kind of authority would that be? Primary authority, mandatory. Since the case can be found from a higher authority within appropriate jurisdiction, it would be primary mandatory authority. Which of the following would be typically considered non-authority? An invalid case or statute, an index, a case not relevant to the research subject matter. An invalid case or statute is one which has been overturned or superseded. An index would never be quoted and is thus non-authority. In some cases, even though a law, blah, blah, we know all this shit. Okay, moving on. The next test is on... I'm going to stop this and do the next one on a different video.